Well, as our last few attendees filter in, let me welcome you all to Redesigning Legal, Exploring the Legal Tech Market. For those of you joining us, this is a reminder that Redesigning Legal is a collaboration between ILS and several ABA entities, including the ABA Center for Innovation, the ABA Center for Professional Responsibility, and the Standing Committee on the Delivery of Legal Services. We are so excited for today's conversation, where we're going to take a deep dive into the state of the legal tech market and how it's propelling the legal industry into the future, while at the same time addressing some of the ethical and underpinnings and concerns that are part of this ever-changing conversation. We're going to have a great discussion today, and moderating our discussion is going to be Damian Reel, the VP of Solution Champions. And joining him on this panel today will feature Daniel DiMaria, the co-founder and CRO at Spellbook, which is an AI-powered legal automation service, and Bridget McCormick, who is the president and CEO of the American Arbitration Association and the International Center for Dispute Resolution. Damian, I'm going to get out of the way and let you lead this amazing conversation.
Great, thanks so much. And I'm thrilled to be here with two titans in our industry, Ms. McCormack and Mr. DiMaria. So maybe could we start with one or two sentences about who you are and what you do? And we could start with Bridget.
Yeah, I'm excited about this conversation. I know I will learn a lot from the two of you. I am currently the president and CEO of the American Arbitration Association, but I've been in this seat only since February 1st. Until the end of last year, I was the Chief Justice of the Michigan Supreme Court. Before that, on the faculty of the University of Michigan Law School.
Great. And Daniel, a few sentences about you.
Yeah, I'm Daniel. I'm one of the founders and Chief Revenue Officer here at Spellbook. We initially entered the legal tech market about 6 years ago or so as a company called Rally. We were in the template automation space, and we started investigating LLM technology a couple of years ago, got really excited by it, and actually rebranded to Spellbook. My background's in law. I practiced law briefly in my native Toronto for about 1.5 years, doing corporate and real estate before getting into legal tech as an entrepreneur.
Great, thanks. And for those who don't know me, my day job is with Fastcase VLEX, where I help both product and other sales and marketing initiatives to be able to talk through the cool things that are happening in the law these days. Speaking of cool things that are happening in the law these days, large language models for the last year has been upending the market. Of course, Avianca, with the lawyers that got in trouble in New York, has raised the eyebrows as far as confidentiality, as well as other Samsung uploading trade secrets and those making their way into the model. That's, of course, on the top of lots of lawyers' minds. So I would ask the both of you, and whichever wants to start, you're welcome. How should we think about confidentiality in the age of our large language models? And are there ways to mitigate and best practices to be able to deal with confidentiality?
Daniel, I'll let you go first, since you've been investigating LLMs for longer than I have. I have been since whenever ChatGPT was released into the public. So you're ahead of me. Go ahead.
Yeah, it's a great question. It's super important. Obviously, information that goes into LLMs that's privileged is a concern. I think for lawyers, some of the best ways to think about it would be to investigate any LLM-based tool that you're going to use, read the terms of use, read the privacy policy, learn how the tools are interfacing with the LLMs, learn the data processing agreements that they have with the LLMs they're using, if they're using off-the-shelf ones, to ensure that the data from either your documents or any queries that go into it are not going into the general LLM pool for training. If you ask some of the vendors that are using LLMs, I'm sure they'll tell you very, very quickly the nature of their data processing agreements with the LLMs. And certainly, a tool like ChatGPT, as Bridget mentioned, if you're using ChatGPT, make sure you're using a version that, if there is one, that isn't training off any of the queries or data that's going into it. So I'd say that's the best way to think about it practically.
And I think there are some, Damian, you can tell me if I'm wrong about this, but I think now almost, or maybe all 3 major cloud providers have a relationship with one of the LLMs. So your firm can, and many firms have, investigate building your own platform that can work together with the LLMs, and then you can build your own secure platform. In the meantime, if you can't get that done this afternoon, there are a few LLMs built on legal texts that at least promise confidentiality. That's what CoCounsel says it's doing, right? So if you're gonna be using an off the shelf one in the meantime, I think Daniel's advice is exactly right, and you probably want to start with the LLMs that are built on legal text for lawyers.
Cool. I would add to both those things, agreeing with them. You can imagine that we've been down this road before with email. That is email secure or not secure? Really, the question is, do you trust your email provider? That is, do you trust Office 365? Do you trust Gmail? And once they get the certifications of being able to, yes, we are DoD certified and we are SOC 2 certified, et cetera, then that trust is established. And so in the same way, each of your LLM providers or each of your first party, you might say, I have a relationship with vendor 1, which relates to large language model A. Right? Do you trust both vendor 1 and large language model A? And if the answer to that is yes, then maybe that takes care of your question. So first, what is the pipeline between the first party and the third party LLM provider? And then secondly, when I did cybersecurity work, I would always advise my clients, what is the secrecy of the thing you're saving? Is it the crown jewels or is it what you had for lunch today? Because how you treat those are varying depending on how much you should be worried about the confidentiality. If it's what you had for lunch today, you have to worry less, obviously, than the crown jewels. And then on the legal side, they have public data, where statutes, regulations, rules, who cares about those, right? Those are public. My client's trade secret, that is the recipe for Coke. You want to be sure not to put that into a large language model. So really the second aspect is be able to say, what are the data types between public law and extremely confidential, and be able to address that accordingly.
Totally agree.
Cool. So let's think about what is exciting. I am certainly excited. I'm sure the two of you are both very excited about our large language model future. What excites you the most, both for lawyers and for maybe non-lawyers in this large language model future that we're in?
I mean, as a top line, what excites me most is the ability to automate the repetitive work that lawyers have to do to be able to allow lawyers to do the more creative, innovative, upstream kind of work that I actually think might make the world a better place if we could focus on emergencies less often and focus more on upstream solutions and interventions. I think we could really contribute to a better world. And for the public, again, this is just top lines, and so I'm sure Daniel will have a much more sophisticated answer. But for the public, the idea of democratizing legal information that I see the promise of, I see on the horizon, is extremely, to me, exciting. Right now in America, at least 92% of Americans get no help with their civil legal problems, and it's really hard for them to figure out how to handle those on their own. And I think that could change, and it could change fast.
And Daniel, thoughts on that?
Yeah, totally agree. Not a ton to add. I mean, for us, what's most excited about LLM technology and the tools that are being built on it for lawyers is a reduction of drudgery and monotony when you're working in documents. It's a huge element of stress, at least it was for me when I was practicing. I know it's true for pretty much all of our customers. The power of this technology being as creative and verbose as it can be, its ability to learn off your documents, your libraries, understand your tone and style really easily without too much building on the lawyer's end, enables most lawyers to really kind of plug it in and have it, do work under their direction that would otherwise be some of the worst type of work, at least as far as it would feel. Of course, a lot of lawyers do bill hourly, so there's an element of reducing the amount of time that you'd be billing. I'm sure we'll talk about this a little bit later. But as far as I know, most lawyers, bill the same for an hour spent, figuring out a legal problem for a client, as much as they spend an hour, control finding a Word document to edit it. So if you can reduce the amount of time spent in those really low value, low satisfaction hours, I think overall it'll make the experience of practicing law a lot more fun for lawyers, a lot less stressful, hopefully. Now, as for non-lawyers, I totally agree with what Bridget said. I mean, the ability for consumers, non-lawyers, people who have legal issues that are maybe basic or not being addressed, to be able to utilize systems. And I'm sure we'll talk about UPL at some point, but being able to ask the civil process for a matter they're dealing with, or ask a general legal question and get just much better personalized answer to what they're looking for, and being able to get at least a couple % into their issue that otherwise they'd be completely lost. Googling the democratization of legal information is certainly something that LLMs are going to have an effect on. Now, I'm sure there's a lot of risks associated with that, as opposed to, I mean, for individuals that would choose to DIY legal issues as opposed to going to lawyers, and LLMs do present a risk around that. But if it's done responsibly, I think I mean, there's tremendous potential to make legal issues, more legal issues addressed than otherwise would be in some way.
Cool. Building upon both of those, both of you talked about the drudgery of the current legal system and the way that maybe large language models might be able to mitigate that drudgery. Something I've thought about and would be interested in your thoughts is that where let's pretend that we have 1 hour to be able to do legal research. That's all the client will pay for. In that 1 hour, I could research one question and it will take me an hour. Option number 2 is to be able to say, I'm going to use a large language model. Instead of an hour, it's going to take me 3 minutes. And now I can go on from question 1 to question 2 to question 20 to question 30 and be able to do way more work in that 1 hour and actually give better work product. Thoughts on essentially ways that we could be able to, that goes into an old joke at this point that, AI will not take your job, but lawyers that use AI will take the jobs of lawyers that don't. That's now an old joke. My new favorite saying is that, yes, AI will take your job, but will take the worst parts of your job and give you a much better job as a result. So maybe we can go into a bit more detail as far as not doing less work, but maybe doing the same amount of time, but providing more work and get rid of the drudgery. Thoughts on that? And maybe we can start with Bridget and then move on to Daniel.
Yeah, I mean, the thing about the LLMs is once you are working at least with a model that you have confidence in its outputs, and we can talk about that New York Times lawyer who I think distracted lawyers. I think that one guy got like the entire legal profession off track for like 4 months. Like, I don't know who that guy was, but I'm still mad at him. I'm still
Mr. Schwartz, yes.
Yes, Mr. Schwartz, yeah. But the ability to do so much more faster is, I think, pretty exciting for the individual lawyers. It does pose this, and maybe this is going to be a topic further down in our conversation, but it does pose a little bit of a fundamental threat to the business model of many law firms, and that's something we should probably talk about. But I don't know how many lawyers get the opportunity to stop during the day and think about the training that they have to be able to provide some services to their clients that really are, I'm calling them upstream, but they're more, dispute prevention services or dispute avoidance services, and the kind of work that lawyers could be doing if they didn't have to spend that hour on that one research project, but instead could have it done in 3 minutes. Imagine if you had the other 57 minutes to work on something that provided far more value to your client than getting to the bottom of that one question that now a machine can do for you.
That's great. Daniel, thoughts on drudgery, getting rid of drudgery, and how LLMs might be able to help that?
Yeah, I mean, there's so many ways that it can help. On the research side, at least for me, when I was starting out, I'd find myself in research spirals where I'm not really getting anywhere, and I know I can't bill a client 8 hours for a fairly not complex question. And being able to leverage AI to maybe bring in some more realistic billing in some cases, or at least write down less hours in situations like that. I mean, that's tremendously valuable to lawyers. There's no question. And LLMs, of course, make research significantly easier. Now, when you're working in a transaction itself, so let's say, so actually, working in a set of documents and utilizing past documents or precedents to integrate into a new deal that you're working on type thing. I mean, what LLMs can do around this, especially with Spellbook, is absolutely incredible. I mean, you could pretty much instruct Spellbook to line by line go through a document and flag certain issues or suggest changes for certain variables or elements, and it can do it in a long document in minutes. It would take a human an hour, and there's really no true legal practice in that part of your day, but lawyers are left to do that more often than not. So I mean, that specifically is is incredible, and I think would make lawyers' lives a lot easier. So.
Cool. Moving on to when I did cybersecurity, we would the data scientists that I worked with would say that the art of data science is not with question number one, but the question that you then say, oh, isn't that interesting? What I've seen in question one. Now I'm going to ask question number two and follow up and say, oh, isn't that interesting? And go to question three and question four. So the answer lies not in question one, but in questions 2 through 20. Of course, that's data science, and so to be able to have enough data to be able to go from questions 2 through 20 is you have to have that data somehow. That is, you have to have a data set to be able to churn through. In the case of legal research, you have to have cases, you have to have statutes, you have to have regulations. In transactional work, you have to have contracts, right? You have to be able to say, here's a precedent of 50 contracts like mine, maybe make a new contract like mine. Maybe could each of you think through on the sources side, what is the I guess opportunity for us to be able to make more sources available for the large language models to churn through, both on the litigation side and on the transactional side. I'll let whoever wants to start.
You can go ahead, Daniel. I keep hopping in there.
Okay. So I guess the question is like, what are the potential power of LLMs once they start tapping into contracts at volume? Is that more?
That's right, and mostly that data is the new oil. You need oil to churn through, right? How do you get the oil?
Yeah. So I mean, as I think about that question, I mean, I think there is a tremendous opportunity for organizations that have a latent database of contracts or legal documents of a certain kind that are really kind of sitting in an inert format and have been up until this point in time. And LLMs enable them to tap into that data and enable it to provide tap into latent knowledge and find a way to leverage it in a way that otherwise really couldn't be leveraged up until this point in time. Whether it's law firms or companies that just have a ton, insurance companies, other companies that are very document heavy, being able to leverage LLMs to generate predictive documents based off their style and form and using their data, that potential certainly exists and is really fascinating. And LLMs enable you to do that relatively easily, I'd say. So, I mean, that stands out to me as potential for the technology.
Yeah, those are that's I think where we'll see all of this going in the next few. I mean, already law, I think, is really ripe for disruption by LLMs because so much of so many of our texts are structured. I mean, statutes and regulations and even court decisions. I mean, they're often in state courts, hard to figure out where they all are. But at the end of the day, it's fairly structured data that's that kind of imposes the rules by which disputes are resolved. So we start with a really big head start in law, in my view, and makes us really ripe for disruption. And then there are all these other, I think, data sets that are within law firms that have been around for 500 years. Okay, that's an exaggeration, but you know what I mean. There are some big law firms that have been around for a long time and they have an awful lot of data. The American Arbitration Association has been around since 1926. We have 97 years worth of data that's never been licensed, right? So there are going to be there's a lot yet to see that can be built because we do have these largely structured data sets that haven't had a tool to put them to use yet, but we now kind of do, or surely will.
Yeah, I just want to add one more thing if it's okay. So I guess something that I just thought about is like there's a lot of organizations that have significant data sets that have been private up until now. Like they really haven't let like other tools like find a way to leverage them in any way. And if you can utilizing LLMs that is completely privately deployed and really nobody else has access to other than you, I mean, like that provides a pretty amazing opportunity for them to get a lot of value from their private data sets in a way that I don't think technology up till now would be able to provide as much value as quickly and cheaply, I think. So that stands out to me. Yeah, I don't know if that helps.
Cool. Bridget and Daniel also talked about, structured data sets. Largely we think of natural language as unstructured data, but of course it does have structure, as Bridget says, that you have headings, you have subheadings, right? You have, sections of a statute, you have subsections of the statute. So in that way, it is quasi-structured rather than unstructured. So maybe thoughts on, either Daniel on the transactional side or Bridget on the litigation and statutory side. Maybe could you go a little deeper as to how you might elicit the structure from what is quasi-structured data? So Daniel, let's start maybe with you on the contract side.
Yeah, for sure. So I'll talk about Spellbook a little bit. So when you open a document in Spellbook, it understands the metadata of the document pretty quickly in an initial scan. So it'll pick up on the key terms. It'll understand all the defined terms. It'll understand it's a machine, so I don't really know what that means, like metaphysically, but it understands it. It's available. It knows the parties. And from that, it's able to really map a document. And what we're working on now is the ability for it to map sets of documents and sets of text files ultimately that are in an unstructured with like some kind of quasi ad hoc structure, but are generally unstructured as far as we define unstructured data sources. And being able to map it and understand it, create like a just-in-time structure, so it can do things with that, like generate outputs that are useful to the lawyers, whether it's like draft documents based off the data set, or reports, or a summarization of risk, or summarization of obligations, and things that are really practical, for the lawyers. So, I mean, that's how we're approaching it. And again, like the ability for an LLM based AI tech to do it really quickly and very accurately is surprising us, as we research the tools and build prototypes and stuff. So yeah, it's very interesting.
Cool. Bridget, other thoughts on quasi-structured data?
Yeah, I mean, I'm no data scientist, but my understanding is that the tools are getting only better and better at taking sort of semi-structured data and making it usable. And as you said, Damien, even in court decisions, there is significant amount of structure. Just think about the judge's name or the panel's name. That's going to be a category of structure that's already there, that you could probably do a lot of learning based on just that one field. Same for usually the title of the legal document. If it's a decision on a motion for summary judgment, you can that's going to be a data field that's very structured, and you can probably do a lot of learning right away. And there's an awful lot of that already in most legal texts. So I'm sorry, in most court documents. Statutes and I think regulations have even more structure to begin with, even though that it's English language or it's language. There's an awful lot of structure to those. So I think there's a real opportunity on the litigation side to build some very effective tools for solving problems.
And I wholeheartedly agree. As somebody who has access to 1 billion legal documents that I'm pulling the structure from the quasi-structured data, there's lots of opportunity there. And a plug for Sally, the nonprofit legal data standard, has a lot of those structured tags, the metadata tags that Daniel talked about. That summary judgment is a metadata tag. Breach of contract is a metadata tag that you could be able to elicit that quasi-structure from otherwise unstructured data.
Yeah, Damien, you're looking at data from legal systems around the world too, right? Are you and are you still finding that the semi-structured nature of it is quickly usable?
That's right. And for those who don't know, VLEX has 100+ jurisdictions, countries around the world. So we have UK data, German data, French data, et cetera. So I'm currently normalizing the Sally data set, which has, as of yesterday, 14,000 tags that matter to US law and around the world. And then I'm essentially normalizing that across all 100+ jurisdictions. Everyone has breaches of contract. Everyone has, patent infringement. Everyone has murder, right? These are all concepts that are universal. But to the extent that there is, things in Indian law, for example, we have an Indian working group full of 100 lawyers in India that are normalizing Sally with Indian law to see if there are any differences in there. And they said to me, Damien, you're missing strict liability. I said, no, 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 look right here. It's strict liability. It's strict product liability. And they said, no, 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 we're not talking about that. We're talking about if two cars get in an accident, you don't have to consult insurance. The insurance just pays for it. You don't have to figure out fault. And I was like, oh, we call that no fault. No, we don't call that strict liability. So everyone has the same concept, but sometimes they call it differently, different things. And so Sally accommodates that through saying that this is a synonym of synonym of no fault is strict liability in India. So it's really being able to normalize that across and so I would say, yes, every legal, as I go through Spain and the UK, et cetera, everyone has the quasi structure that we have because humans think in quasi structured way. This is a section where you talk about breach of contract, and then you move on to the patent infringement. We put those in headings, and those headings are parsable. Let's move on to the next. Bridget, you talked earlier about the billable hour, and I think Daniel did too. Maybe it's time to talk about that 800-pound elephant in the room that we've talked about. Mark Twain would say the death of the billable hour has been greatly exaggerated over the last 40 years. Are we maybe at the cusp of the billable hour dying? And the question is, can lawyers, if they move to the flat fee, realize that if they push their costs down, they can increase their profits to be able to actually make more money with the flat fee than with the billable hour? What do you think? Billable hour dead, dying, or not even close to being dying? What do you think?
Maybe I'll talk about it. I'm sure Bridget can add a lot more insight to this one. I don't know. I'm skeptical that it's dying. Honestly, at this point in time, I think a lot of legal work, even with LLM technology enabling them to be a lot more efficient than they otherwise could be, lawyers are very accustomed to putting all the non-deterministic risk of a legal issue on the client, and clients are used to paying it, and they have it for a long time. When it comes to flat fee, it really is a complete reversal of risk, right? In this case, a lawyer is taking on the full risk, and when there are unforeseen issues for the matter, which there often are, the lawyer needs to bear the cost of that, or need to adjust their fee, or have some sort of schedule to do that. I think just because the technology makes lawyers a lot more efficient, I don't think it means that the billable hour is threatened directly until law firms start to implement flat fee billing systems around increased efficiency from the LLMs. And I don't know if we're seeing that from our customers just yet, and I don't know what it would take for that to happen. But until we see that happen, and clients are able to see that in all kind of segments of the legal market, I don't think we're going to see the billable hour really go away.
Cool. Bridget, what do you think? Billable hour dead, dying, or not even close to dying?
I mean, it definitely it feels to me like it's already in zombie form, but it sure is a strong zombie. I've thought it was on its way out a couple of times in the past 15 years, and I've been wrong. But I think it's not only the billable hour, but it's the leveraged model that a lot of law firms bill their hours on that feels really in jeopardy right now to me. I mean, there are a number of those law firms' clients who have already asked the law firms to explain how they're using LLMs to bring down costs. And a lot of those in-house teams have been using the LLMs themselves, and they see that it might not make sense to pay the associates hourly rate for at least some of the tasks that they had been paying for a long time. So I don't see how that doesn't change quickly. And I think some of the law firms are already figuring out what the new model looks like and spending some time on it. And if they're not, I think they should be real soon.
That's very true. We've thought and talked a lot about the Gravatt model, where a partner has a bunch of associates under them that the associate churn, and then the partner makes money based on that associate. That's the old model. You can imagine today's, I could ask an associate, or I could ask my trusty large language model that the associate takes 2 days, but the large language model takes a minute. And so I guess the real question is, are we moving from one partner and a bunch of associates to one lawyer, one matter? And that's, I think, the real question. And can law firms make more money with one lawyer, one matter than they can under the churn model of the associates? That is the open question of the hour. I know that what I just said probably terrifies lots of people, including the questioner who is in there saying, how do we see LLMs impact the use of paralegals and the legal assistants in the future? I think that maybe what I just said might be one answer to that question. We'll move for one lawyer, maybe a junior partner level up, which their trustee associate is their large language model, or maybe one human associate to be able to bounce things off, but they might not need a legion of associates to be able to leverage. And where do associates and where do paralegals and assistants fall under that? I would say probably under the pecking order from the associates, but really who knows? I would say that what I just said is probably terrifying. So let's move on to our next topic, which is we've said what's exciting about legal tech. What's terrifying about legal tech? What are you scared about that maybe we might need to address? What are things that we should mitigate as we enter our large language model future? And I'll open that up to whomever wants to start.
I mean, I'm not a good person on this question because I am not scared of a lot. I'm far more excited than scared of most of what is coming. And so maybe I should let Daniel tell us what I should be more scared of. And I'm sure I don't know as much.
Yeah, I guess there's a couple things that come to mind as that could be scary for people. For one, I'm definitely mindful of law students. I was a law student not too long ago. The law school model right now, it looks like is built on, students taking on a good amount of student debt to educate themselves, and then going into practice at firms to pay it off over time. And if LLMs can replace lawyers, which may or may not be true, or at least reduce the number of lawyers that are needed to do grunt work, a lot of that work is done by new lawyers, where they really cut their teeth in that kind of work. So if we believe that to be true, it's possible that over time, and based on the speed in which the technology is being adopted, maybe not a long time at all, a lot of these law students that have spent decades more cutting their teeth on that monotonous, grindy work that teaches them are going to see that work be reduced across pretty much every segment of the legal market. And what effect that'll have on their employment and especially the early formative years of their career is one that could cause a lot of problems for them. And it is a type of career where a lot of lawyers are taking on a lot of debt to go to school, so that really compounds the risk for them. So I'm certainly, as someone who's a law student not too long ago, it's something that I'm concerned about, for one. Now the other one, which I think is the bigger one and affects more people, is around the unauthorized practice of law risk of these technologies. It's not terribly hard for a company to connect to publicly available LLMs, create a user interface, sell it as a SaaS product or something to non-lawyers, and say, hey, here's your lawyer bot. When you have an issue, ask it to do things for you, whether it's build a contract for you or answer legal issues, questions for you, review documents for you. I mean, it's not easy, but it's not terribly hard for companies to start doing this. And whether or not it's illegal to do that, it probably is. There really aren't any natural safeguards in place to prevent people from seeing these tools that are perhaps built in an irresponsible or janky way and believing that this truly is a lawyer bot, and trusting it with their legal issues and dealing with the consequences of those, which can be severe. Whether it's family law issue, criminal law issue, or private law issue. I mean, it could be horrible for them if the LLM hallucinates, which it's wont to do, or provides bad advice, or puts them into a promise that they otherwise shouldn't be in the private law case. And that's a huge issue, and I think we're going to see that a lot more over the next few years as these tools get built. And unfortunately, it's probably going to affect a segment of the population that probably couldn't afford a lawyer. And in a lot of cases, it's going to be harder for them to deal with the consequences, the negative consequences, when those arise. So, that'll be a challenge that we'll have to deal with.
Cool.
I have a couple.
Go ahead.
No, I have
And
a
go ahead.
couple reactions to both of those. I mean, I share the view about the value of legal education and how we are probably going to have to think about what legal education looks like, rethink what legal education looks like. And right now, I don't think there are a whole lot of law schools that are retooling what they're teaching and how they teach it. I think I know the few that are even training students on these new tools, and it's very few. So I do think that's a real issue. The UPL issue, I'm far more excited about than worried. Just because my answer is always as compared to what. Right now, most people get no help with most legal problems, and there have been self-help websites that we in states have, built over the last 10, 20 years to try and help those folks who are never going to get legal help from lawyers. We're never going to lawyer our way out of the civil justice crisis we're in. And I see far more upside potential there than downside.
That's really all insightful from both of you, and that goes to John Mayer, who I assume is the John Mayer from Cali, that talks about why can't paralegals plus large language models do much of the work for lawyers at the low end for much less cost? And I think that's absolutely right. That is there anything indicative about the JD behind my name that makes me as a new graduate more authoritative to answer than a paralegal that's worked in this area in the last 20 years and knows exactly what Cook County's housing requirements are. Nothing magical about the JD, and large language models plus that paralegal of 20 years is probably going to do a better job than me, to the better than what point that Bridget had.
In fact, there's some data saying that the paralegal who does domain specific legal work over and over and over again is far better than the generalist JD. There's actually pretty good data out of the UK on that. So
yes,
yeah,
100%. It's just us figuring out, including the ABA, figuring out that maybe this is something we should be thinking about. To the law school point, that Daniel, a really good point. I'd be interested in both of your thoughts. If our one matter, one lawyer future comes to pass, one could imagine that a lot of associates might be doing the work for access to justice. Maybe they aren't going to get that big law big law job with $200,000 a year that they were hoping for when they went to law school. Maybe they're going to be doing access to justice for a much lower salary. If there are fewer of those associate things, then you can imagine then the $100,000 or $200,000 worth of debt that I put on to be able to go to law school, maybe that will be less attractive if I'm a prospective law school. Am I going to spend $200,000 going in debt when I'm not going to get the $200,000 a year job, but I'm instead going to work for $60,000 or $70,000 for that legal aid organization? So legal education, if they're doing it right, they're going to be thinking about that maybe pipeline shrinking, where the smartest potential law students might not be going to law school because there will be fewer lawyers to be able to associate jobs doing that work. Thoughts on whether the law schools might get the picture on that shrinking pipeline, or whether hope will spring eternal and new law students will say, I will be the 0.5% that makes $200,000.
I mean, I think right now, unfortunately, most law graduates don't get those jobs. It's a very small number of lawyers who work in big law and make the kind of salaries that associates at Cravath make, right? Most law students graduate from lots of law schools where that's not in their future. And in fact, the ABA data and other data shows that 80% of lawyers are fully employed. An awful lot are not fully employed right now. So I think there's already a little bit of brokenness in our legal education system. And I think we might be, this might provide a moment for us to figure some of that out. I mean, we have this system in legal where the stakeholder groups who are all partly responsible for lawyer formation and licensure and access to justice kind of don't talk to one another, right? The legal education system, the licensure system, the state Supreme Courts, the bars, the state bars, and the accreditor all kind of work in their own silos and rarely talk to one another. And I have this fantasy that this could be the moment where we all kind of come together and figure out how we can better serve students who want to go to law school, the public who desperately needs the services of people who graduate from law school, and produce a much better version of our profession.
I 100% agree. Dennis Kennedy has a really good question. Dennis Kennedy of the Kennedy Miguel Law Report. He talks about historical data and LLMs and bias that might come from that. Of course, bias. Another word for bias is history. that is the precedent is bias. That is, our law is biased because the law goes one way or the other. But of course, there are also unwanted biases. So thoughts on from Bridget and Daniel as to biases in the large language models themselves, and then biases in the systems that utilize those large languages. Is this something that we should be thinking about? And if so, how?
Yeah, I mean, I don't think it's too much of an issue, to be honest. I think if you instruct the LLM for what you're looking for in a clear enough way and blunt enough way, you'll get a pretty good answer, and it'll also come along with sources in most cases, depending on what you're using. And in the case of a bias around utilizing your own transactional knowledge base for transactional type work, you kind of want the bias to come through to kind of see how like the lawyers built the knowledge base tend to answer certain questions and provide certain language, certain issues in a document, let's say. Yeah, I mean that's all I have to add on that. I mean, Damon, I think you could talk a lot more about the bias in research. So
good.
Yeah,
Bridget?
I mean, I think obviously it's something we have to be thinking about in any model that we're using. The difference between an LLM and humans doing legal work or making decisions is you can debias an LLM, and it's really hard to debias a judge. Really hard. I mean, we try, but we're humans, and it's much easier to debias an LLM than a human.
And LLM bias, you could see it right there in the data. Human bias, good luck reaching into the brain to be able to see the thing that happened to that person at 6 years old that makes them biased now forever. There's also one aspect. When I worked at Facebook, there were posters all over that said, not everything you count can be counted, and not everything that counts can be counted. So not everything. Yeah. So the idea with that bias is that something that matters is that the judge and that lawyer got in a fist fight at age 15. That's not going to be in any of my court data, but that matters, right? And that is not quantifiable data, but it matters. So there are certainly biases that are unquantifiable, but do matter. And so with the large language models, at least those biases can be pointed to and remedied. Your finger.
I mean, everybody's aware of this, the data about criminal sentencing, and you never want to be sentenced by a judge who's up for election, like I think within like 30 or 45 days of the election date, or right before lunch. Like you don't want to be sentenced by a judge right before lunch. That you're much better off coming back at 2 o'clock when they're not hangry. And the thing about LLMs is they don't get hungry, they don't get tired, so they don't have those human factors issues that humans have.
Indeed. There's another question that kind of relates back to the hourly billing, and it goes. This is from Peter, and it asks essentially value billing. We have historically, and most of us today, bill by the hour. Hours are easily quantifiable, but if we go to flat fee billing, we have to instead say, here's the value I'm providing, and here's why my hitting the engine just like this, you should pay me $1,000 because I had to figure out where exactly to hit that. It took me 20 years to figure out where to hit that in the engine. So thoughts on legal value billing? That is, if we do move away from the billable hour and we move toward, I spent 15 minutes on it, but I'm still going to charge you $3,000 because it's that much value. Are we going to reach that point with the legal profession?
I think probably yes. I think that would be a lot more in line with a lot of other types of services and products that you buy, and hopefully we'll get there. Yeah, I'm all for it. I think it's great. I mean, also on the lawyer side, it enables them to, in some cases, if they have a fine enough tuned system using technology, they can be rewarded for it. They can increase their effective hourly rate. If it takes them less than an hour, they can bill a lot more for. It also provides the opportunity for uncapped earnings for a lawyer. I mean, you can only bill so many hours in a day, right? If you can have an amazing system that you can scale using technology and provide advice with just as much care, maybe you should be compensated for that.
Cool. Bridget, thoughts on value-based billing and whether we'll get there?
I mean, to me, it's stunning that we're not there yet, right? I mean, it just shows the staying power of some of the orthodoxies within our business structures. But I think value billing is where we're headed, and the law firms that are right now already thinking about what that looks like and how to state their value proposition and how to sell their value are going to have a real advantage right now. I think we could have a real reshuffling of lots of the law firms as well as law schools. Frankly, I think there's a moment right now where folks who are not in the T14 can jump ahead.
Agreed. There's a question from Iyad asking, he's asking in the micro, is there a way to use LLMs to enhance my job-related skills incrementally? Is his question. That's a micro question, but there's really a macro question. Is the legal profession can we use large language models incrementally? And I guess my question for both of you is, it's long been said that change happens very slowly and then all at once. And so really with large language models and AI, it seems like we have been going pretty slowly, but in the last year or so, we've gone really quickly all at once. So thoughts on whether we're still going to be incremental or whether it's going to be a lot all at once?
Yeah, I don't really know. It's hard to predict. I think we're only okay. So this is mentioned. I'll give credit to this from Jake Heller at ILTACon. He mentioned in his keynote that if LLM technology did not get better right now, it remained static and how good it was right now, it's going to drastically change several industries over the next 5 years, even where currently is at. So I think we're going to see in the adoption side, we're going to see a lot of changes to how people work with this fundamentally. But on the technology side, I mean, are we going to see another LLM from the pre-LLM world to the post-LLM world level of technology? I don't know the answer to that. I maybe a little skeptical.
Bridget,
yeah, I think our human brains can't quite understand how fast things are changing and how much they're changing. I think that's literally true. But just based on the rate of change I feel like I've seen over the last 2 months, it feels like all at once is the answer. I think we're going to have enormous change, that things are not going to look the way they looked a year ago right now for a long time. It's going to be a totally different world.
I agree. Speaking of totally different world, John asks how will contingency fee personal injury practice be affected? And I think this goes to the hourly billing versus the flat fee billing. A contingency fee is a type of flat fee billing. I can say personally that I spoke to a bunch of plaintiffs' lawyers, the American Association for Justice, and all of them were licking their lips saying, wow, I can be able to shrink my costs by doing a 10-hour task for 1 minute, and then essentially all the rest of that is profit that I could be able to do. They're having at it. So I would say, at least my thought to John's question is that, of course, contingency fee is going to be one of the first adopters of this. And then once the contingency side, the plaintiff side takes advantage of it, the defense side is going to have to take advantage of it because their insurance companies that are paying their bills will demand that they will do that. But thoughts from Bridget and Daniel as to whether what I think might be true?
I agree with that. I think contingency fee is value billing. I mean, if you can convince a potential client that you are the right lawyer, that they should share their victory with you at a 70-30 rate, then you're communicating your value proposition to that potential client. So I think they're already there. I would expect, though, that the market would force a little competition if, in fact, it doesn't take you nearly as long to earn your 30% fee, then the guy down the hall might start offering a 20% contingency fee, right? So the market should work to the advantage of the consumer at a certain point, even in a value-based fee system, which I think contingency fees are.
Cool. Daniel, any additional thoughts on that?
No, that's exactly where my head was at. Yeah, I mean, hopefully we see contingency fees go down. I mean, that'd be great for the public generally, I think.
Sure. Great. Let's talk. Knowing that we have 12 minutes left to be able to talk, let's talk a bit about AI in courtrooms, and then move on to the regulation, the UPL. So we've talked a bit about that. So Judge McCormack, we can start with you to be able to say, having been a judge, how do you see the AI, the large language models, being used both in the preparatory stages before things go into the courtroom, and then even within the courtroom? Thoughts on how large language models could be used in both?
So here's one place where maybe I should have answered your "what am I worried about" question earlier. I'm a little worried that courts are at a bit of a disadvantage to figuring out how to make use of these tools for the benefit of the court users, so that the public that needs courts. I mean, for even when you have an innovative forward-looking court leader, a chief judge or a court administrator, they're publicly funded and, you know, have to navigate politics. And, you know, this one person on the county board doesn't, you know, is afraid of technology. And so all of the things that court leaders, even the most innovative court leaders, have to navigate to be able to offer better service to court users are really complicated. And so I think courts are in a tough way. I have had a lot of courts reaching out wanting to learn. I'm doing a presentation tomorrow to a group of judges, and did one a couple of weeks ago to the Conference of Chief Justices. And so I think that they're at least spotting that there are some things they're going to have to worry about, but they're not sure how they're going to manage it. How to think about lawyers using it feels to me to be a little bit of a red herring. That again, that guy I can't stand from the New York Times article, like, I think set us all back, because I think our ethical rules already govern what he did. I don't think we need any new special like tools to tell people not to make stuff up and put it in court pleadings. You're already not supposed to do that. Like, don't do that, no matter what tools you have to do it. On the other hand, the technology is getting so sophisticated for, you know, what I think the public thinks of as deep fakes, but that those show up in all kinds of ways. And those are going to be really complicated for publicly funded, busy public servants to be able to sort out. So there are I think there is a little bit of a rocky road ahead for some courts. There are also some big upsides for courts that have spent a lot of time thinking about how to give self-represented litigants the tools and the information to be able to navigate their justice problems. There's some upside opportunity. Those courts that have already built those platforms can upskill those platforms tremendously if they want to. I mean, they have to convince their legislatures to fund it, and again, that's complicated, but.
Yeah, that's true. Then I'll jump to Daniel if he has any additional thoughts on this. But I would say that when I would clerk for a judge, often I would say, Your Honor, plaintiff said, defendant said, I think you should say. But of course, plaintiff said it in page 1, defendant said it in page 20. And being able to essentially connect those dots is a lot of work. You could imagine a large language model being able to connect those dots and be able to draft that bench memo in a much more quickly done, to be able to not do the work of a judge, but just to expedite the work of the judge, to be able to get them to the answers more quickly. I think lots of judges don't consider that as a way that large language models can help rather than hinder. Daniel, knowing that spellbook is in contractual law, and if a contract ever makes its way to court, something went wrong. Any additional thoughts on large language models could be done in courtrooms?
No, not really much. I mean, of course, I'll just say it's always a lawyer's responsibility to review any output that an LLM generates, even if it is highly trusted, because yeah, it's not a lawyer.
Cool. Both of you have talked about the unauthorized practice of law, and so maybe we can move on to regulating legal tech and the extent to which it should or should not be regulated as unauthorized practice of law or not, and then also how, if we do classify it as the unauthorized practice of law, what are the implications for access to justice? So maybe I'll start with Daniel on, since you brought it up, the UPL side. Thoughts on unauthorized practice of law and whether LLMs may constitute it or not, and the implications for access to justice?
Yeah, so kind of already said before, but my mind is I'm not decided on this. I'm still thinking about this issue. I think if you present an LLM as an LLM-based software to the public as one that can answer legal questions, I think that might present a UPL issue. It might appear to be like a lawyer-client relationship has in some way been created with that software. I do like what Bridget said around a lot of these people wouldn't otherwise be able to work with a lawyer due to the cost, and an LLM-based system would provide more legal advice and substance and help than they otherwise would get from any other source. It's the best way to do it. So I think when it comes to I think on the access to justice question, the only answer is that this technology is going to improve access to justice. I don't see any world in which that doesn't happen. I hope it's done in a responsible way, but I don't see any reason why it won't under any timeline that we go down with this technology already existing, even if it doesn't get better, which it will. So
cool. And same question to Bridget, and I would add another caveat to this to say, will it affect UPL and access to justice? And then, because Bridget McCormack has probably thought a lot about this, what is the difference between legal information and legal advice, or is there any difference? So thoughts on either of those things?
Yeah, I mean, we could spend the entire hour on just this topic, but we have about 4 minutes. But so stepping back for a minute, I mean, the UPL statutes evolved, right? Like at the founding, you could get legal help and advice from people who were not lawyers. By the way, can you think of any other profession that refers to people as lawyers and non-lawyers? Like we don't call people doctors and non-doctors. Like I'm a non-doctor, but here I am talking about. So I have a little bit of skepticism about the entire UPL framework. So I'll just fess up right there at the top. But in large part because I know how many people are navigating civil justice problems without lawyers, and some of them are trying to go to court. I mean, in fact, I think the National Center for State Courts estimates that about 73% of civil cases in state courts, at least one party doesn't have a lawyer. That's a stunning amount. That's a stunning number of people. If you walk into a local state court eviction docket or debt collection docket, you will largely see people who are don't have lawyers, trying to understand and speak a language that they've never been trained in. And it's fundamentally unfair. It's fundamentally unfair what we're doing right now. And so I think we have to be pretty aggressive about thinking about how these tools can help more people and be a bit of a breakthrough that we've needed in the massive market failure of the civil justice system. It's really about the rule of law. At the end of the day, if most of the country doesn't have access to the legal system that people with money have access to, they're going to stop believing in the rules. And the rule of law is just a set of ideas that needs the public's confidence in it. I feel like this has to be a breakthrough moment for us, and that's how we should be thinking about it.
I 100% agree. Yes. So in the 2 minutes we have left, let's look into our crystal balls, and let's look at the last 12 months since ChatGPT came out and really turned our world upside down, and think about the last 12 months, and let's look forward to the next 12 months. I feel like the last year has seen an exponential curve. Of course, in the next 12 months, we might even out and plateau, or we might keep going up. Thoughts on where we are on this curve, and maybe we could start with Daniel.
I think we are. I think we're close to the beginning of the curve. I do. For the legal profession and other professions, I think the legal profession might be a little further along, just based on the fact that text is the currency of law. I mean, the output of practice law are text documents, and because LLMs work with text directly, it's more it just affected so early. I think in the life cycle of this, but I think we're right at the beginning, and we're going to see it. We're going to see it do things that are going to shock people. I think. 100%. We're at the beginning. That's what I think.
Cool. Bridget, thoughts on where we are in the curve?
I mean, what Daniel said, I mean, I don't think it's a curve anymore. It's not up and to the right. It's like straight up already. And I think it's just going to go straight up faster. I mean, I can barely keep up from week to week. I try Tuesdays and Fridays, like figure out what happened in the preceding 3 or 4 days. And my head sometimes spins and I have to take a break.
Agreed. An anecdote to agree with what both of you said, an anecdote to follow upon that is that every time a lawyer says to me, boy, I hope I retire before all of this comes to pass. In my brain, I don't say it out of my mouth, but in my brain, I say, I hope so too. Because then you will make way for the younger lawyers that will actually be able to do things better, faster, and stronger, than that don't have the UPL hangups and don't have the kind of ways, the old ways that just don't work anymore. So I think maybe it being two minutes before the end, I think this might be a good point for us to end. And I want to thank both Bridget and Daniel for really what I think has been an enlightening conversation. And I hope to have more of them in the future with Joey or otherwise.